The subcommittee number 2 at general laws to order. We've got 10 bills on the docket and a full committee and a subcommittee after this. So let's get rolling. Delegate Sullivan, if you'd like to come up and present your House Bill. Roll call. Let's take the roll before we get rolling. All right, we've got a quorum. Delegate Sullivan, you have House Bill 1888. Please tell us what your bill does.
Thank you, Mr. Chair. Good afternoon, Mr. Chair and members of the committee. HB 1888 has to do with real estate closings, and I do have some line amendments, which I believe Council has.
Council, would you please report the line amendments for Delegate Sullivan's bill?
Line 21, after fees, strike from the seller without first obtaining the seller's written informed consent and insert payable to the settlement agent from a represented seller without first obtaining the written consent of the seller's counsel. The second one is line 34, after collect, strike the remainder of line 34 and through consent on line 35 and insert any fees payable to the settlement agent from a represented seller without first obtaining the written consent of the seller's counsel.
Move the amendment. Second.
It's been motioned and seconded on the amendments. All those in favor say aye.
Aye.
Any opposed? All right, those amendments are properly before us. Delegate Sullivan, if you tell us what your bill does.
Sure. Thank you, Mr. Chair. What 1888 does is simply clarify who pays what fees in a real estate closing in which the seller is represented by counsel. It simply requires notice to the counsel for the seller and counsel's consent to any fees that the settlement agent wants to charge to the seller. It's not onerous. It's not time-consuming. We're not looking to slow down any transactions. What it is directed at, Mr. Chair, members of the committee, is it protects consumers so that they know who they're paying and what they're paying for. There is peace in the valley in the sense that I'm aware of no opposition to the bill at this point. We've been talking to the stakeholders. The language, as you see, has gone through a little changing. We think it's improved the bill. I think the stakeholders feel it's improved the bill as well. So I hope the subcommittee will look favorably on 1888.
All right, let's hear from some stakeholders. All those in favor of this bill, please come forward.
Thank you. My name is Todd Condren, and I'm a stakeholder who is in support of this bill. I'm in a pretty unique position to testify in the sense that, on one hand, I'm an attorney who's been practicing for 20 years in real estate law, and a specialization of my practice in Northern Virginia is representing sellers in real estate transactions. And on the other hand, I'm also a principal owner of a large independent settlement company, which has 9 offices across the state of Virginia. So I've looked at this bill from both perspectives, as a representative, as an attorney of sellers, and also as somebody who is a settlement agent and practices in real estate settlements. And I do support this bill mainly because it is a consumer protection type of statute where by adding this language, you're going to prevent sellers from being double charged in certain scenarios, represented sellers, I should say, from being double charged for essentially the same services in a real estate transaction, and giving the opportunity simply for sellers to consent to charges that are attempted to be imposed upon them by settlement companies. One thing I want to echo is Delegate Sullivan's language that it really will not create any undue burden for us as a settlement company at all. And quite frankly, it's there mostly as a consumer protection statute to protect sellers from paying costs, not only from double costs on their side, but also for paying for no services being rendered at all. Okay?
Thanks, sir.
Mm-hmm.
Mr. Chairman, Erin Corman with the Realtors. We also support this bill. This is an issue that our members have brought to us many times over the past year since the BOI letter went out. There's a lot of confusion. I think this letter is a step. This bill is a step in the right direction, and we support it.
Thank you. Anyone in opposition to this bill? All right, seeing none, it's back to the members of the committee. Are there any questions?
Mr. Chair, move to report as amended.
There's been a motion to report as amended and seconded. All members, please cast your vote on the board. All right, Delegate Sullivan, your bill reports 7-0.
Thank you, Mr. Chair, members of the committee.
Thank you. Delegate Bloxham, 1805, you're up next.
Thank you, Mr. Chairman. House Bill 1805 simply adds to the Christmas tree of things that the VRA can do bonding for. What this is trying to increase the inventory of housing, so it gives the local government the ability to bond projects related to preservation and increasing the housing for moderate and low-income people. And that's basically, Mr. Chairman, all it does.
Thank you. Is there anyone here in favor of the bill who wants to come forward and speak? Anyone in opposition?
Mr. Chairman, move to report.
Wait, there is a substitute. I'm sorry.
Yep.
All right, we have a substitute. Is there a motion on the substitute? It's been motioned and seconded. All those in favor of the substitute say aye.
Aye.
Any opposed? All right, substitute's properly before us. Delegate Bloxham, tell us what your substitute does.
Does the same thing, just correct some errors.
Excellent. All right. It's been motioned. We need a new motion, actually, if anyone.
Move to report the substitute.
Is there a second? All right. It's been motioned and seconded to report the substitute on 1805. All members, please cast your vote. Thank you, Delegate. Your bill reports 7-0.
Thank you, Mr. Chairman.
Yep. Next up, Delegate Lopez. You have your House Bill 2058.
Thank you, Mr. Chairman, members of the subcommittee. This bill has to do with condemnation or the tenant's assertion for condemned rental units. In Virginia, it's possible to be evicted without going through the usual eviction process. When a rental unit is condemned due to the landlord's severe neglect and inability to properly care for that unit, the tenant can be removed. This is essentially an eviction. Under Virginia law, landlords have a very clear responsibility to make repairs and other types of general maintenance to ensure that a building and its rental units are safe, healthy, and habitable. When landlords completely ignore their duty to keep a building and its rental units safe, clean, and habitable, a rental unit can be condemned. And when a rental unit is condemned, the tenant has little to no legal recourse. What this bill does is provide a clear legal remedy for tenants who lose their homes through this form of eviction that is often the result of a landlord's extreme neglect of a property. This bill allows a tenant who is effectively evicted from their home because of health and safety reasons to file a case against his landlord for money damages equal to 3 months' rent and the amount of the security deposit paid by the tenant. It's very often the case that landlords don't return security deposits to their tenants when something like this happens. The mechanism by which a tenant could file a case against a landlord to this bill would be what's called the tenant's assertion, but it differs in 2 important ways from a typical tenant's assertion case filed against a landlord who is neglected to make 1 or 2 specific repairs. If a tenant files a tenant's assertion after their unit is condemned because of a landlord's neglect of their responsibility to upkeep the property, there will be a presumption that the landlord breached their duty to keep the home in a safe and habitable condition, and the tenant will not be required to pay anything into court escrow. That's very important. The tenant will not be required to pay anything into court escrow in order to maintain the case. Evictions are often ugly and awful and negatively life-changing events for people, and you see this happening a great deal of the time with someone who is living in these conditions. They don't have the money to live someplace else, and so their ability to, effectively engage with paid attorneys is not that easy. So this will help these poor folks who are stuck in these horrible conditions, I think, become whole. Thank you, Mr. Chairman.
Thank you. Is there anyone here in support of this bill? Please come forward.
Thank you, Mr. Chairman, members of the subcommittee. Christy Marrow with the Virginia Poverty Law Center, and we do support this bill. This is a sadly common occurrence where landlords, in particular corporate landlords, larger landlords, often out of state corporate landlords who are not present to check on their property, are allowing the property to fall so deeply into disrepair that the locality has no choice, after issuing numerous notices of violations that go unheeded, to condemn the property, leaving the residents that are left there with absolutely nowhere to go. And as noted by Delegate Lopez, most of these residents have little or no assets or income, at least not enough income to be able to move somewhere healthy and safe for themselves and their families. So we do support this and ask you to do the same. Thank you.
Is there anyone else in support of the bill? Anyone in opposition to the bill? Seeing none, it's back to the committee. Delegate, I'll ask you a question. Where is this happening in Virginia right now?
It's happening in every corner of the Commonwealth, but I'm seeing it a lot in Northern Virginia. You've seen some fairly horrible situations with derelict condominiums, small apartment complexes where it's happened, and I can give you more details as well off the record.
Delegate Carr. There's been a motion to report.
Second.
And second. There's another motion. If you'll open the roll for a vote. All right, Delegate, that bill fails to report on a 5-2 vote. You have another House Bill 2075. If you'd like to present that bill.
Yes, thank you, Mr. Chairman. Most jurisdictions in the United States residential or provide residential leases to include a warranty of habitability, either explicit or implied. This warranty holds landlords accountable for maintaining a habitable property, even if the lease itself does not specifically require that the landlord make repairs. Virginia has a warranty of habitability written in the state code. Unfortunately, however, the vast majority of residents in the Commonwealth are unaware of these provisions in the code, allowing many landlords to take advantage of their ignorance of the law in order to skirt their duty to provide fit and habitable conditions. Even worse, some landlords have argued that their duty to comply with these provisions can be waived during the rental process as long as they receive oral or written approval from the tenant. This is an area where, again, the lack of awareness of many renters or language access, in some cases up, especially in my neck of the woods, is used against them by bad actors in order to avoid their responsibility. As many renters are not aware of these provisions or their duties contained within, many do not know how to seek recourse for violations or even that they may well be within their rights to seek any recourse at all. This bill would simply do two things. Landlords will now be prohibited from waiving their duties under Virginia's warranty of habitability law, either orally or in writing. And two, landlords will now be required to include the terms and conditions in writing governing this duty in every rental lease agreement. Just two simple fixes to strengthen the rights of tenants, prevent them from being taken advantage of by a small number of unscrupulous bad actors. I hope it's the will of the committee to pass the bill.
Is there anyone here to speak in favor of House Bill 2075? Is there anyone in opposition?
Good afternoon, Mr. Chairman, members of the subcommittee. Tommy Herbert, representing the Virginia Apartment Management Association, as well on behalf of our sister organization, the Apartment and Office Building Association of Metropolitan Washington. We appreciate the patron and what he's trying to do. However, this is duplicative of wording that is already in the Virginia Code. And in regards to tenant education about their rights and responsibilities, we are now required, every housing provider in Virginia, to provide the tenant statement of rights and responsibilities at the outset and at the renewal of each lease, which covers these exact rights. So we would respectfully ask you to oppose the bill.
Mr. Chairman, Aaron Corman with the Realtors. We also oppose the bill.
All right, it's back to the committee. Are there any questions for the delegate?
Mr. Chairman.
Delegate Bulova.
Yeah, thank you, Mr. Chairman. And I guess maybe a question for Mr. Herbert, if you don't mind. So I guess I heard, with regard to the education part of this, and so that is really critical, right? Because most of these individuals aren't going to read the Code of Virginia to figure out what their rights and responsibilities are. I did want to get down to the other part of this bill with respect to making sure that you can't waive those rights and undermine, I think, the work that we've tried to do to ensure that tenants are protected. But I'm interested in kind of hearing your thoughts about whether that in itself is something that might be able to go ahead and stand the test of legislation this year.
Mr. Chairman and members and Delegate Bulova, we would say that I believe it is 55-1-1208 that already explicitly states that a tenant cannot waive, or a landlord cannot ask for rights under this section to be waived. I'd be happy to get you the exact citation, but that language is already in the VRLTA.
Okay, thank you, Mr. Chairman.
All right, it's back before the committee.
Mr. Chairman.
Final word from Delegate Lopez.
Just, even though it is in the VRLTA, what's happening a great deal of the time, especially up in my neck of the woods, where you have 108 languages spoken just in my district and 58 languages spoken in my local high school, the fact that we're not having a piece of paper that has to be handed to them during the rental lease agreement, and the fact that it's not being done, it's just simply taking place all the time where you're not having this information conveyed, and the confusion is enabling landlords to be much more aggressive with tenants in my own backyard along Columbia Pike on a it's happening far too often. And if it's happening far too often in Northern Virginia, I'm sure it's happening on every corner of the Commonwealth.
Thank you, Delegate. It's back before the committee. Operates by motion. It's been a motion and second to report and a substitute motion. There's a motion to lay the bill on the table. Is there a second? There's a second. Bill's motion to lay on the table. I'd ask the clerk to please call the vote. That bill is laid on a table on a 4-2 vote. Thank you, Delegate.
Thank you, Mr. Chairman.
Let's see. Next up, we have Delegate Head, House Bill 2312.
Thank you, Mr. Chairman. Members of the committee, House Bill 2312 is a bill that was created after the governor's Make Virginia Home plan and his home tour that he did last year. It advances some of those plans. It allows a contractor and a developer to recoup attorney's fees if a stop work order is overturned in court, and also defines what a stop work order is. Very simple. Just the idea is that it would try to put a stop to any locality that issues stop work orders that are frivolous. They are very hard to defend and very expensive. And if they appeal it in court and it's overturned, they can recover all their attorney's fees and costs. That is the bill.
Thank you. Is there a substitute or any amendments on this bill?
I do not believe so.
Okay. We have a question from Delegate Bulova.
Yeah, thank you, Mr. Chairman. And I guess in looking at this, I guess the flip side of the concern that I might have is the chilling effect that this might have for local governments to impose stop work orders for what could be a myriad of egregious violations, particularly if they know that it's kind of one-sided, with respect to attorney's fees. And so I know with a lot of these kind of bills, it's not that one person has the right to get attorney's fees and the other doesn't. It's whatever the prevailing party is, and that way both of them have skin in the game. But have you thought about whether that might be a fairer approach rather than just being able to have one?
Well, Mr. Chairman, Delegate Bulova, my thought on that would be that that works out real well when you're dealing with two private parties. But when one of those parties is the government and they already have all of the chips on their side of the table, this just begins to level the playing field, which is already largely unlevel when it comes to a decision like that. This is not something that can be negotiated out, and if what it really would call into question is don't issue a stop work order for egregious violations unless there really are egregious violations. Be sure of what you're doing, which is what government should be doing in the first place. And if it's there and if it's upheld, if they try to appeal it and they lose the appeal, they're still out. But it's a little bit different than it would be if it was a civil matter. So,
Delegate Coiner.
I think in line with Delegate Bulova's question, unfortunately, we've seen some of these where property owners start building and it's by right, and folks don't like what they're able to put in places. And so one of the ways that government can slow it down or irritate what they don't want built is by issuing these stop work orders. And their attorneys can keep working because they're not racking up per hour rates. And at some point, they know it's a business decision for people. And so I have seen this abused in practice, and think it's important that folks treat this seriously, and it does come up. So,
thank you. I'd like to hear from anyone that's here in favor of the bill. If you could please come forward, state your position.
Thank you, Mr. Chairman, members of the committee. My name is Brian Horn. I'm the Director of the Department of Housing and Community Development. I'm not going to repeat the delegates' comments, but on behalf of the administration, we strongly support this bill.
Thank you. Anyone else in favor? Any of those in opposition to the bill, if you would come forward, please.
Bonnie Atwood. I'm with David Bailey Associates, and I represent the Virginia Fire Prevention Association. We are opposed to this bill. The reason is the possible chilling effect on stopping work because of fire safety concerns.
Thank you. It's back before the committee. Delegate Head, you have the final word.
Again, I think you've heard both sides and just would ask the committee to act favorably on this
Move to
piece of
report.
legislation.
There's been a motion second to report House Bill 2312. Ask the clerk to please open the roll for a vote. That bill reports on a 5-2 vote. Delegate, thank you.
Thank you, Mr. Chairman, members of the committee.
Delegate Reed, you're up next. You have, let's see here, House Bill 1766. Tell us what your bill does.
Yes, thank you, Mr. Chair, and thank you, members of the subcommittee. One of the things that we've heard a lot of discussion about, whether you're in favor of it or against it, is the whole discussion about electric vehicles and whether or not we have the charging infrastructure to be able to accommodate those vehicles. One of the things that I think that we have to recognize in a way to address this particular problem is that studies of current electric vehicle use is that 80% of the charging occurs at home. Now, one of the things that we have to recognize is that at home is defined differently for different people. It could be a single-family home, it could be a townhouse, it could be an apartment, it could be a condominium, it could be a farm. And what this bill intends to do, and it's prospective in nature, so it would only apply to future multifamily dwelling units, and those would be defined as attached townhomes, condominiums, and apartments. It would require that during the planning and design and construction phase that the infrastructure be put in place to be able to accommodate future installment of electric vehicle charging. So it's not mandating that anyone has to install chargers, but as we all know, that during the process of actually building a new development, it's a lot less expensive to put in that conduit, the extra circuit breaker box, the extra electrical room, than it is to actually have to go back later, dig up asphalt, put that in, or put in these additional things as a retrofit. So that's the intent of the bill, Mr. Chair, and I'm willing to take any questions.
All right, I'm not seeing any questions popping on the board just yet, but we'll take testimony from the public. Anybody who's here in favor of the bill, please come forward and state your position.
Mr. Chairman, members of the committee, I'm Nikki Robner. I work for the Nature Conservancy. We support this bill. We are moving towards electrification, and as Delegate Reed said, asking people to make sure that those parking lots and parking areas can provide charging in the future is going to be really important, and I think folks are going to be sorry if they don't provide that infrastructure. I have been authorized to say that the Virginia Auto Dealers Association and the Alliance for Automotive Innovation also support this bill. Thank you.
Thank you. Anyone else in favor of the bill? We've got some speakers online. I would ask Ms. Johnson if you would call our first witness.
Mr. Speaker, we have Susan Stillman.
Ms. Stillman, if you could unmute, go ahead and turn your video on and state your position.
Hi, this is Susan Stillman. Can you hear me? Thank you.
We have you loud and clear.
I'm here on behalf of the Virginia chapter of the Sierra Club, and I'm speaking in support of this bill. I won't repeat what the delegate said it does. That's all pretty clear. I do understand that there's been some pushback from the builder community saying that there's a perceived risk of fires when you put EV charging and have electric vehicles in parking garages. That's a non-issue because of 100,000 vehicles sold that are gasoline powered, 1,530 of them catch on fire, whereas only 25 of 100,000 EVs catch on fire. So it's really not an issue to put this charging infrastructure in a building. So thank you, and I hope you will pass HB 1766.
Thank you. Ms. Johnson, do we have anyone else in the queue on this bill?
Yes, Mr. Chair, we have Ben Kessler.
Mr. Kessler, if you would unmute and go on video and tell us your position.
Yes, good afternoon, Chairman and committee members. My name is Ben Kessler. I'm the Public Policy Manager for ChargePoint. We are the North America and Europe's largest charging provider. We support HB 1766 for a myriad of reasons, but certainly Delegate Reed touched on the cost. We've seen studies and actually, through our own assessment, about a 5-fold decrease in cost to do it at the onset of new construction versus retrofit for EV-ready buildings. And then equity is a big issue. renters generally do not have access to home charging. So having an ability to negotiate with your homeowner or landlord would be a really great plus to enable access and equity in EV charging for those that participate. And the other thing I think that needs to be touched upon is workforce. This bill would certainly increase the opportunities for trades such as electricians, construction workers, installers, and deployers. And so we look forward for support from this committee. And thank you very much.
All right, it's back to the committee. I don't see any. Oh, yeah, I guess we do need to hear from some opposition. Anyone that's in opposition to the bill, please come forward. State your position.
Mr. Chairman, Andrew Clark with the Home Builders Association of Virginia. Wouldn't disagree that I think EVs are obviously an emerging and definitely a rising consumer demand. One of our issues is that, in Virginia, we adopt a building code through a regulatory process that involves fire officials, building code officials, the industry. That really allows for these things to be vetted, both looking at the international code and then looking at what's going on in Virginia. And so we do have concern with adopting building code provisions through the General Assembly session. We saw last year there was effort to roll back energy efficiency standards, and that actually made it into the code. So I think there needs to be a clear distinction between a regulatory document and what happens in General Assembly. To Ms. Stillman's point, the fire concern was not raised by the home builders. It was actually raised by a Northern Virginia building official in a locality who's actually had some issues with EV fires in parking decks and multifamily structures. So did want to clarify that. We've had these discussions during the current building code update. Weren't able to reach consensus, but know that these conversations will continue moving forward. Thank you.
Thank you. Next speaker, please.
Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We support the concept of the bill, but as a rule, we also don't, we oppose anything that legislates the building code. And on the off session, we were also having these discussions and fumbled around that 25 to 30% number. However, the fire department stepped in with those concerns. Those were also not initiated by us, but we don't want to legislate the building code. So we ask that you oppose the bill. Thank you.
I almost thought we were going to get through these last two bills without hearing that we weren't going to legislate through the building code, but I'm glad it's here. Again, we have some questions from members of the committee. Delegate Fowler, you're up first.
Thank you, Mr. Chairman, and I think Delegate Reed and I have kind of discussed this the other day a little bit, but I'm inclined to agree. I'm a little bit uncomfortable about doing this here and really do think the place for this is in the building codes when they, adopt new regs and all this, that, and the other. They're experts on this, and obviously, while I did have the capability to wire my own house and it hadn't burned down yet, I think we really, need to. Just thought I'd throw that in there for some fun. But anyway, I really do think that the building codes folks need to take a look at this.
Thank you, Delegate Fowler. Delegate Bulova.
Yeah, thank you, Mr. Chair. And I have been rueing this day because I really do feel very strongly about electric vehicle infrastructure and making that available. And so I hate to fall on my sword for a principle, but I do strongly in my heart believe it served us very well for various different ways to go ahead and try to legislate the building code. Some of those things I like, other ones haven't liked, but trust kind of the professionals who go through the regulatory process to make sure that we're focusing on safety and things like that. So I would hope that we not cross that Rubicon and legislate the building code.
All right. Delegate Reed, you have the final word.
So thank you, Mr. Chair. To both Delegate Fowler's and Delegate Bulova's positions, as well as the folks from the Home Builders Association, I think it's important to point out that in here, it is directing that the board that does the building code will promulgate the regulations. So they would need to bring all of those stakeholders together so that we could actually have the professionals do this. Another version of this legislation would have empowered localities to do it through their comprehensive plans. And I pushed back and said, no, I don't want to do that because we really can't have a patchwork of these solutions across the Commonwealth for the very reasons that you've said. But again, at some point, we need to get beyond talking about the fact that there is an issue for electric vehicle charging infrastructure and start taking some directive action about how we're going to address this. And I think that this legislation would be able to do that. So I thank you, Mr. Chair.
Thank you. Delegate Corner.
I think the only thing I'd add to this conversation, when you look at affordable housing and where we try to build projects, and sometimes they're in infill areas where, based on the property we have left, you only have enough space for X. And if a locality believes that the project's good, they try to give flexibility to make it work. And the more things that we legislate, and they don't have the ability through the building code and through their local ordinances to do that, sometimes we lose the ability to provide housing, or we lose a business that could go. Sometimes localities let them double count spaces, right? The residential can count it, and we'll also count it for your commercial, but does it go to the 25% if the commercial's using it? I just think these are best left for building code and local ordinances to handle, and with that, I'd move to gently lay the bill on the table.
Delegate Corner, could you restate that motion for me?
I move to lay the bill on the table.
All right, thank you. And that was properly seconded. I'd ask the clerk to please open the roll for a vote. All right, that bill is gently laid on the table. Delegate Reed, thank you for presenting that bill.
Thank you, members.
All right, let's see. We'll take up Delegate Delaney's House Bill 2135.
Thank you, Mr. Chair, and thank you, committee. So what this bill does is it expands the type of protective orders and documentation by which a victim of sexual abuse or other criminal sexual assault may terminate their lease. Under current law, victims of these crimes are able to terminate a lease with a permanent protective order. The issue is that a permanent protective order requires a conviction, and oftentimes a conviction takes longer than the term of a typical lease. And so I've partnered with a variety of advocates and have presented this bill that will add a variety of other protective orders, as well as language about other agencies by which a victim can seek records that they could demonstrate to the landlord to be able to terminate their lease. This is a situation where if someone is a victim of sexual assault or abuse, there are many reasons why they may need to leave the residence that they are currently in for their safety. Waiting until a conviction and waiting until the permanent protective order is in place puts victims at risk to be unsafe at home. Now, we have heard from a variety, there's a lot of interest represented here. And, I'm standing here with advocates for, victims of abuse. But I understand that, there are folks here that are representing those who own the properties and would like to try to find a compromise where we can help make sure that these people are as safe as possible in their homes while recognizing that there are other interests. And so I've worked, I have met with VEMA and I've worked with the realtors. There are some proposed amendments, and I'm not sure if the chair would like to hear from testimony from those who have different varieties of position on this bill before considering some perhaps more common ground approach forward. But I know that those who are advocating for the bill, I know there are some who would like to speak, and there may be some thoughts about
I'd like to get those amendments before the committee. If you could ask. All right, the amendments have been moved and seconded, but I would ask our council to report those amendments. Okay. We have. So have you?
I can bring those over. So what we would be doing would be striking the reference to 19.2.152.8, which is the emergency protective order. And I can send this to council to maybe work in concept while testimony. I don't know how the chair would like to handle that while testimony is heard. But it also tightens up the definitions regarding the clergy, making sure that they're duly ordained, commissioned, or licensed. It strikes. Let me see. And then it adds professional license by the State Board of Medicine or Nursing or a mental health service provider. And so what the purpose of the amendment does, and I'll pass that to council in a moment, is to just better define who some of those entities are.
All right, Delegate, just a question on your strikes. You said you wanted to strike the 19.2 152.8 section. Is that correct?
Yes, Mr. Chairman.
Okay. We'd like to get our substitutes in before committee, but for now, we'll let you pass your amendments to council for them to look at and see how we can incorporate those. There's been a motion and a second on the amendments, but we're going to hold off and let them look at them real quick, and we'll call for public testimony while they're being looked at. Anyone in favor of the bill, if you could please come forward.
Good afternoon, Mr. Chairman, members of the committee. Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We're very appreciative to the patron for bringing this forward and see this. We wholeheartedly support this bill as a measure to expand access to safe housing for victims of sexual and domestic violence, particularly for those who are not eligible for a family abuse protective order at the moment or for whom that particular type of remedy would not be appropriate. Additionally, our sexual and domestic violence agencies who are named in this particular legislation are ready to work alongside landlords and property owners as well as victims to ensure that the proper documentation is there in order to facilitate that process. Thank you.
Mr. Chairman, members of the subcommittee, Christy Marrow with the Virginia Poverty Law Center. We also support this legislation. The current law is restrictive and doesn't allow for all victims and survivors of domestic violence and dating violence to terminate their leases. Right now, the law only allows folks who have a family abuse protective order, and we think one of the most important things that Delegate Delaney's bill does is to allow people who get protective orders from the General District Court because there is no family relationship with their abuser to also use those protective orders to terminate their leases, and we ask that you support the bill.
Good afternoon, Mr. Chairman. Isabel McLean with Housing Opportunities Made Equal of Virginia, and for the reasons previously stated, we support this bill.
Good afternoon, Erin Corman with the Realtors. We just want to thank the delegate for working with us because I know we had a lot of concerns with the original language. We do feel much more comfortable with the amended language that we've seen. I think that's what's been handed over. We did have one concern that I know we brought to the delegate about the clergy language that I think may need to be tweaked a little bit. So if we're going to have that discussion, I just wanted to put that out there. But we don't oppose the bill. We are hoping that we can get it where it needs to be.
Mr. Chairman, members of the committee, Tommy Herbert with VAMA and AOBA. We would associate ourselves with comments from Ms. Corman. We do have concerns about the sections dealing with documentation. However, we want to be supportive of the concept.
Thank you. Is there anyone in opposition to the bill that would like to come forward? All right, we do have some online speakers. Ms. Johnson, if you could allow Mr. Turkheimer.
Stefan Turkheimer.
Yes, thanks very much. Chairman Wampler and members of the committee, I'm Stefan Turkheimer representing RAIN, the nation's largest anti-sexual violence organization. I come to you in support of Delegate Delaney's bill, House Bill 2135, that will fulfill the promise made in the current code section of 55.1.1236 to protect victims of sexual violence from ongoing harm. That section purports to allow victims to terminate their leases, but it can only be accessed by victims of sexual assault if they obtain a conviction for rape. That happens way too slowly and infrequently for it to ever help these survivors. Fewer than 1/3 of victims report to police, and less than 1% of offenders ever get convicted of rape, which the protecting statute requires. Sexual assault trials drag on for a long time, even when the perpetrator is known by the victim, often for years, longer than the vast majority of residential leases. If you want this statute to be anything other than a false promise, it needs these changes. This bill is based on who survivors actually tell when they've been sexually assaulted. It's based on real situations where people need immediate help. It must address assaults where the survivor doesn't know the rapist's real name and where to find them. It should not require permanent protective orders that seek to prevent an offender from ever going back to a property. This is about the victim no longer being there when he arrives. I'm grateful to the committee for considering the protection of survivors of sexual violence in this bill, and I'm happy to answer any questions you have.
Thank you. Our next online speaker, Victoria Horick.
Thank
Thank you, Mr. Chair and members of the committee. My name is Victoria Horak. I'm an attorney with the Legal Aid Justice Center. We represent low-income tenants across Virginia, and although we don't specifically practice domestic violence related law, many of our clients are violence survivors, and this bill would expand the number of people who can protect their families by breaking their leases without a penalty. These folks are in crisis when they're trying to get out of their house, usually to escape their abuser, and they need to keep their families safe. As the other supporters have said, there are massive barriers before those folks can get permanent protective orders or a conviction. So this would allow more survivors to be able to move their families safely. So we support the bill.
Thank you very much. Delegate Brewer.
Thank you, Mr. Chair. Question for the patron.
The
Delegate
floor.
Delaney, I'm reading your bill, and I wish I would have looked at this a little bit sooner and quicker. I have some grave concerns about the bill. Can you kind of tell me how this came about? And to be honest with you, I know there's a lot of industry friends out here. Is there any one major offender in the industry that you feel like wouldn't allow someone to end their lease? Is that your major concern, and how did the bill come about?
So thank you, Mr. Chair. To answer the delegate, this was a bill that was brought to us that we've been working with RAIN, and we've also been working with Action Alliance, and that is the concern, that we have situations where victims of abuse are unable to break their lease and unable to leave their situation, or may just feel, that it's a reason why they feel trapped because
Mr.
they
Chair?
have a lease.
Delegate Brewer.
Follow-up question.
Yeah,
Can you be specific? What counties is this happening in?
Well, Mr. Chair, I don't have a list of specific counties that it's happening in, but I think that the Code of Virginia says that it could happen anywhere. That the problem we're trying to solve is that anywhere in Virginia, a victim could feel trapped in their current living situation because they are unable to break their lease.
Follow-up question.
Delegate Brewer.
I empathize with the intention of your bill. What I don't see is I don't see anybody here with a story where this instance has happened, and I'm concerned when we open up something such as this without conviction that we're going to have people abusing the system or making false claims, because in fact, indeed, those things do happen, and that's awful. I would ask, though, is there a remedy with the industry stakeholders with letters of support? I can't imagine anyone in apartment communities or major realtors or anything of that nature, they couldn't work out finding a way to end a lease. Well, are you concerned about that?
Mr. Chairman, I am concerned about that. I think that the reason why this bill was brought forward, the reason why we just had a line of testimony in person and in support, is because the advocates who work with victims of abuse are seeing this happen. They're bringing me this bill because they're watching it happen. They're watching the survivors that they work with every day struggle with these kind of issues. And so they're bringing forward the request for this legislation because in their real life, situations that they encounter in their professional lives, as advocates, are witnessing it happen. And I think we as legislators, have to listen to those stories that are coming from our advocates. I don't think they'd be here testifying for this bill if they didn't have examples of times where this would have helped someone get into a safer environment.
Mr. Chair.
Delegate Brewer.
I want to speak to the bill, and I have a motion at the appropriate time. Delegate Delaney, I empathize with your bill, and I empathize with the people that are talking about it. But what I also see is the opportunity for people without conviction to truly drive a truck through the middle of this bill, and it concerns me greatly. I think that this bill isn't ready for prime time. I think we probably need to sit down and honestly look at this. I think it could get better. And so with that, I would make a motion to gently lay this bill on the table.
Well, Mr. Chair,
It's a non-debatable motion. There's been a motion to gently lay this bill on the table. I think it's got a good chance if you continue to work on it and try not to allow the preliminary and temporary orders, which don't provide an opportunity for hearing for both parties. I think there's some other issues out there. But anyway, I would ask the clerk to please open the roll for a vote. Thank you. All right, that bill is laid on the table on a 5-2 vote. Thank you, Delegate Delaney.
Thank you, Mr. Chair.
We have a couple of bills left. I'm going to ask the clerk if you will send a patron notification to Delegate Price. Oh, there she is. I didn't see you in the crowd. Come forward, please. You have House Bill 2441.
Yes, thank you, Mr. Chairman and members.
I had not intended on coming back before you, but on the last day that we could file bills, I was made aware of an entire complex in my district that was going through an issue. They had been moved to month-to-month leases, and all of their leases were terminated. This is nearly 100 people at one time, and as of this week, they were to have been all moved out. I have emailed each of you a link about all of these residents and what they're going through, and I do want to be clear. What happened to them right now is currently legal. With month-to-month leases, you only have to provide a 30-day notice. And that seems fine for most folks that are purposefully on a month-to-month leases because they want that flexibility. But what about the families who want to stay in their homes and had no idea that their lease was about to be terminated? Mr. Phillips, in the story that I sent you, is a 22-year resident, and he said, I'm sure you know what it takes to move from one place, find a new place, and there are all these things you need to do and take care of. And to have been given such short notice like that, it is just inhumane. And his sentiments really do represent a lot of the residents that are finding themselves, in fact, unhoused because of this situation. So this bill would require 60 days notice be given so that it gives not only the residents more time to find somewhere else, but it also helps the current overpowering of these situations with our current social services departments. So faith-based communities, nonprofits, even hotel owners that want to help are finding 30 days just not enough time to help them. And so that is the bill, and I hope you will look upon it favorably.
Thank you, Delegate. Quick question before we take public testimony on this. The way I read your bill, it seemed that a landlord would have to evict 20 tenants or more in 30 days before a notice would be required to be given. Have you found any language over the last couple of days that would kind of address that and help with that?
We found language that is similar, but unfortunately is not all the way applicable based off my conversation with our amazing counsel. I am open to whatever amendments can help because truly my intention is for the one locality being overpowered in their social services department. I'm not trying to get to 20 units across the whole Commonwealth, but Newport News, Hampton, Richmond, some localities in Northern Virginia, those of us that are experiencing already high numbers of evictions, now having to deal with this problem on top, we just do not have the resources to help our residents.
Understood. Let's take some public testimony on this. All those in favor of the bill, if you could come forward and state your position.
Thank you, Mr. Chair.
We're going to take in-person testimony first. Ms. Zare, if you could hold on for a minute.
Thank you, Mr. Chairman. Christy Marrow with the Virginia Poverty Law Center, and we do see this. It's really very common for our clients who are tenants to have leases that either begin as month-to-month leases because that is what they're offered, or begin as year-long leases and convert to month leases automatically at the end of that period. One of the things that we've been seeing actually are corporations, largely out-of-state corporations, coming in and buying up large apartment complexes where people are already on those month-to-month leases, and then doing exactly what Delegate Price is talking about, providing 30-day notices to dozens, if not more, tenants all at once. And it does get overwhelming for all of the agencies in the area who are trying to provide services and referrals for these individuals so that they won't fall into homelessness. We think this is an excellent way to start to address that problem. The extra 30 days really can help people get in touch with and access services in time for them to be helpful when they have to move out. And so we ask that you support this legislation.
A question for the witness, just briefly. Now, this bill would apply to private landlords, but in the public sector, in our public housing developments, we have a lot of assistance in place already for those tenants when there is eviction to help with, transitional housing and finding, additional housing for our tenants in Virginia public housing. Is that your understanding?
Mr. Chairman, there is an entire different set of rules for tenants in public housing. And as a matter of fact, those tenants generally are not on month-to-month leases. They are on one-year leases, and the federal government is presently looking at potential agency action to extend their notice for everyone, their termination notice, all the way up to 30 days. So I think it's a very different situation, and they do have protections already.
Thank you. Next speaker, please.
Isabel McLean with Housing Opportunities Made Equal, and we support this bill. Thank you.
Thank you. Is there anyone in opposition to this bill? If you could come forward, state your position.
Good afternoon, Mr. Chairman, members of the committee. Tommy Herbert with VAMA and AOBA. We respect the patron and we sympathize with the situations that she is trying to address. However, we must respectfully ask you to oppose the bill. Month-to-month leases are a proper legal instrument that are freely entered into by people for all types of reasons every day. We would respectfully say that the integrity of those leases has to do with the term being 30 days rather than 60, and therefore we would ask you to please affirm current law and oppose the bill.
All right, we have some online testimony. Ms. Zaire, if you could unmute and tell us your position.
Thank you, Mr. Chairman. My name is Larissa Zaire. I'm an attorney with Legal Aid Justice Center. We support HB 2441. LAJC regularly works with long-term renters who struggle to find new housing in less than a month when their month-to-month lease is terminated. Many long-term renters in Virginia don't have a year-long lease despite living in the same place for decades. And currently, when a landlord redevelops their property, they only have to give these month-to-month tenants 30 days to uproot their lives. Just last year in Arlington County, where I work, we saw a landlord end the leases of about 60 families at once. That left those 60 families scrambling for new leases in a tight housing market, changing schools and packing up their lives. Many had lived there for over 10 years. Even though their landlord in that case gave them around 45 days, more than the required 30, every day was critical for their stability. And all this bill does is ask the landlord who has had years to plan redevelopment to give their tenants just one more month to move. Please vote yes on HB 2441 so that renters can land on their feet. Thank you very much.
Thank you. Delegate Coiner.
Thank you, Mr. Chair. So I completely understand the problem, and I'm trying to figure out within the language how to address it. And I hear the argument from the apartment folks that you have a 30-day agreement. But the issue is, when you have, I'm going to use a real example. We had an apartment complex in my district when I was on the school board. And they gave notices to everyone. And all of a sudden, they all went to the same elementary school. When they got evicted, the school division had to figure out how to bus everybody from wherever they found occupancy and move to temporarily, because that's what the law says. If you don't have housing, we have to figure out how to get you back to your home school. And 30 days was not enough with the number of families that were impacted to figure that out. So there's a public cost on the public side to not figuring this piece out. And, when someone decides they're going to, in this case, they had a bunch of zoning violations and they had to make repairs, and the easiest thing to do was to get rid of everybody at one time and do it and then do new leases. When that, as a large landlord, when that's going to happen. And so, there is a public cost on the opposite side of us not figuring this out. I don't think this language solves it. And so I've been sitting all day trying to figure out how do we change this. So I am supportive of this. I just don't think this fixes it, and I'm struggling to figure that piece out. I would say maybe some of our folks in the public housing sector have a solution. I know when they negotiate their leases, they provide provisions for if this large turnover happens. I'm just struggling that I don't think this language solves it.
And if, Mr. Chair, if I could add just one difference, and I think one of the witnesses was trying to get to it. This company, the owner switched everyone to 30-day leases. That's what they were offered. And if they didn't want to sign that, they could leave. That is a very different situation than someone that says, hey, I would like to enter into a 30-day lease. And so I do want to differentiate between, like I said, the people that want the flexibility of a short-term lease versus those who have lived there for 22 years and would like to just have more notice to pack up their things and leave. And so I appreciate the sympathy or empathy, but I would really like to be able to take home some help, some actual help, not feelings. And I mean that with all due respect, but this is like the fourth bill that is directly from a situation coming out of Newport News that just does not seem to get there. And I am very frustrated with that.
I understand, Delegate, and I will tell you that I've spent more time trying to think about how to get this language right than many of my own bills this session, and I kind of tend to associate my comments with Delegate Coiner in that, you know, the way this bill is written right now, I don't see it being effective to try to prevent the type of thing that you're trying to prevent, but I totally understand where you're coming from. And so,
Mr. Chair.
Delegate Coiner.
I would ask that I would like to move to report, and I'd like to speak to that motion.
Delegate Coiner.
You know, I don't think the current language, I can't support the current language, but I think if we allow this to make its way to full, then perhaps the patron can work with other folks on trying to fix the language. And if we can't fix it before full, then it doesn't move forward. But I think if we all wrap our heads together around the type of situation we're talking about, perhaps we can keep struggling with it. That would be my motion to report as amended.
Mr. Chair.
Let's give Delegate Price another word.
Yes, thank you. I really appreciate that, and I do understand that that is also today, but I do think that there's someone very close to me that might have an idea, so I would appreciate that opportunity, knowing that there's another subcommittee between us and full.
You got it. Actually, today is the last subcommittee in full of general laws, I believe. Before
there's one in between, between us and full.
I believe her motion was to report based on us coming up, and I'm publicly saying
I understand what you're
coming up.
Forgive me, I understand what you were saying. All right, there's been a motion to report this. Is there a second?
Second.
All right, it's been motioned and seconded to report Delegate Price's House Bill 2441. I'd ask the clerk to call the roll for a vote. All right, that bill reports on a 6-1 vote. Thank you, Delegate. Good luck in the next hour. All right. Our final bill that we have up, I believe. Nope, we have two bills left. We have House Bill 2048. Delegate Carr, if you'd like to present wherever you're comfortable.
Thank you, Mr. Chairman. Do so from here, if that's all right. We'll be looking at HB 2048 about ensuring the affordability of housing in economically mixed developments. This bill would implement a recommendation from a 2021 JLARC study of the state's affordable housing needs. As part of that study, JLARC reviewed the affordable housing programs operated by the Virginia Housing Development Authority. This bill amends a program that the General Assembly previously permitted Virginia Housing to operate to ensure that the program's housing units are actually affordable to low and moderate income households. The program is referred to as Virginia Housing's Workforce Housing Program, which funds mixed income developments. State law requires Virginia Housing to set aside 20% of the units in these developments for households earning low and moderate incomes, but does not currently require that those reserved units have subsidized rents that are more affordable to those households. When JLARC staff examined this program, they found that the rents for units that were being set aside for low and moderate income individuals were only slightly less than the rents charged in other units. For example, the average rent difference per month for a one-bedroom unit was only $15 per month. Additionally, many of these households were paying more than 30% of their income in rent for these units. Households that pay more than 30% of their income toward housing costs are considered housing cost burdened, and the housing is considered to be more costly than what they can afford. This bill changes the code to say that not only must 20% of those units be reserved for households with low and moderate incomes, but that the rents charged on those units must be lowered to be more affordable to those households. Simply put, this change simply clarifies that the rents in these developments are affordable to the people for whom they are reserved. And, Mr. Chairman, I have folks here from JLARC who can clarify and speak more on this.
Is there any questions from members of the committee? Seeing none at this time, I'd ask for anyone in support of the bill to please come forward.
Mr. Chair.
Delegate Brewer.
Sorry, I was just starting to look at the bill. Question for Delegate Carr.
Go ahead.
What projects right now are underway or in any localities that you can recall that might be affected by a bill such as this?
I would like to, if I may, turn over to the JLARC folks, because they're the ones that came up with this study.
Delegate Brewer, is this a question for JLARC or the delegate?
Whoever can answer it.
JLARC.
Good afternoon, Mr. Chairman, Delegate. My name is Stephanie Papps, and I was the project leader for the Affordable Housing Study at JLARC. I think that the bill would only apply to developments that are new developments. It wouldn't apply to developments that are already in the program.
Follow-up question, Mr. Chair.
Delegate Brewer.
Can you identify any specific projects right now that may not be completed that this legislation would affect?
No, not at this time.
Thank you.
All right. Anyone in favor of the legislation, if you could come forward. Anyone opposed to the legislation, if you could come forward.
Good afternoon, Mr. Chair, members of the committee. Damus Boudreau, representing the Virginia Housing Development Authority. We definitely appreciate the delegate. We identified problems early on with this legislation and tried to find a solution, and we did not get there. The governor's office, the administration, does oppose this bill. With me, I have Art Bowen, our managing director of rental housing, if there are specific questions about the mechanics of the bill and why we don't like it. But that's what we got. Thank you.
Delegate Brewer.
Thank you, Mr. Chair. Question.
Yes, ma'am.
Would this bill affect possibly any federal monies at all?
I'm going to defer to Art Bowen.
Thank you.
Mr. Bowen, welcome.
Thank you. Good afternoon. To answer your question, ma'am, I do not believe that would be the case. The only possibility I can think of, some localities are using their federal ARPA money towards housing. So it is possible that some of these projects could have that money in them, but right now I'm not aware of any that actually do.
Mr. Bowen, did you have any other comments in relation to the underlying bill?
Mr. Chairman, if I may, we have heard from a number of our customers who operate in this program, or loan customers, that they have concerns about the actual administration of this. So this requirement will be in place typically for at least 30 years, potentially even longer. They would have to comply with it, and the mechanics of rent restrictions can become very complicated. The program, as it's currently structured, simply has an income restriction that's easy for them to determine at the point where a tenant applies to move into an apartment, but the rent restriction is going to be a moving target. The developers who do business in this program typically do not deal with rent restrictions. We have other programs that are designed to be 100% affordable housing where that's common, but it's a very different ballgame, and we are concerned that as a result of this, we might lose some business in this program.
Thank you. Next speaker, please.
Good afternoon, Mr. Chairman, members of the subcommittee. Tommy Herbert with VAMA and AOBA. We would associate ourselves with the comments from Virginia Housing Development Authority. We are in a deep, deep housing shortage at all price points, and we would hope that anything that would have a chilling effect on getting us out of that shortage, we would oppose. Thank you.
Good afternoon. I'm Sarah Taylor with the City of Alexandria. We have used this product on projects in the City of Alexandria to protect and expand our affordable housing in our community, which is sorely lacking, and we're always looking for more. And we echo the concerns that this would have a chilling effect on our ability to find development partners to work using this product. So we, while we appreciate the intent, we do oppose the bill.
Thank you. It's back before the committee. Delegate Carr, do you have any other comments? Please
yes,
go ahead.
I'd like to say that, you know, if this is if it's people's money going into this people's project, there ought to be money for the people that are renting the units. But I'd like to give my last word over to Hal Greer, who's head of JLARC, who headed this study.
Sure.
Good morning, Mr. Chairman, members of the subcommittee. I'm Hal Greer, the director of JLARC, and I'll be brief, Mr. Chairman. Mr. Chairman, when JLARC staff conducts a review of an agency's programs, one of our fundamental charges is to evaluate whether an agency is properly fulfilling its statutory mission, as well as the legislative direction that it's been given in the execution of its responsibilities. This bill is born out of the finding from the JLARC housing study that the workforce housing program as executed by Virginia Housing is not meeting the agency's primary mission to provide affordable housing to low and moderate income families. And it's not meeting the fundamental purpose of the REACH fund, which is the fund from which the subsidy for this program comes. The primary purpose of REACH is to create housing opportunities for low-income Virginians. And finally, it's not meeting a key legislative purpose of the program, which is to make 20% of units in these developments available, and by implication, affordable for low and moderate income households. This bill would enact the JLARC recommendation that this program be tightened up through statute and help to ensure that Virginia Housing is properly fulfilling its mission and meeting all the purposes of this program. Thank you.
Mr. Greer, did you work on the language for this bill at all with the delegate?
We did work with Delegates on this.
Okay. What would keep someone, a prospective developer, from just increasing the unrestricted rent, thus making up the difference for the restricted rent and lower cost units from this language?
I'm sorry, increasing the unrestricted rent amounts?
Bill says that there's going to be a restriction on 20% of the units, and that rents shall be at least 10% below the rents of the unrestricted units. So what's to keep a developer from just increasing the cost of the unrestricted rents and then reducing 10% from that to make up their pro forma, however they've figured it out?
Mr. Chairman, I think that's a good question, and maybe the language needs to be tightened up to address that issue.
All right. Are there any questions for Mr. Greer? Seeing none, Delegate Carr, final word.
Thank you, Mr. Chairman. I'd be delighted to, if we could put this aside and work on tightening up that language. I think this is a really important issue, particularly in this time of needing affordable units and affordable units for population that sometimes doesn't have them available.
All right. Thank you, Delegate Carr. Committee operates by motion.
Mr. Chairman, I move to lay it on the table. Second.
There's been a motion second to gently lay House Bill 2048 on the table. I'd ask the clerk to please open the roll for a vote. That bill is laid on the table on a 7-1 vote. We have a final bill up in the bills to be heard today, and that's Delegate Bulova's House Bill 2098. Delegate.
Thank you.
Tell us about this great bill.
Thank you, Mr.
And all
Chairman.
it does.
And actually, I do have amendments, and probably would make more sense to adopt them now if it's okay with you, so that I could explain as I go along.
There's been a motion on the amendments. Is there a second? Is there a second on the amendments? All right, there's a second on the amendments. All those in favor say aye.
Aye.
Any opposed? Okay, tell us what the bill does and then what your amendments do, please, Delegate Bulova.
Great. So thank you very much, Mr. Chairman. And this is actually an issue that Delegate Coiner and I had a chance to work on a little bit with the Housing Commission this last year. It kind of came late in the process, so we weren't able to go ahead and iron everything out. But I think there was general understanding from the Housing Commission that it was an issue that was worth dealing with. The purpose of the bill is to bring better clarity to this section of the code dealing with the enforcement powers of common interest communities, and more specifically to fix a loophole that makes it very difficult to deal with repeat violations. And so this is an issue that was raised by a condo association up in my district, but I know other associations have struggled with the same issues. I guess let me kind of lay out the kind of the pattern that is the problem here. And so the way the current code reads, a person in violation of the rules is then given a reasonable opportunity to correct the violation after they're given proper notice, right? So that makes sense. You're given a chance to go ahead and cure that. And so only then, if the violation remains uncorrected, then there is a hearing. The person could go ahead and present the case. The HOA or the condo association can make a determination, and then they can go ahead and impose a fine. The maximum fine is $50. So that works really well for things like painting your house the wrong color. Because it's something discernible. You go ahead and change it the right color, and you can avoid the fine after proper notice. Same thing with putting up a wrong kind of fence or something like that. And the only way that you wind up with a fine is if you ignore the board's notice and you wind up having to go to a public hearing. But let's say you get busted for a noisy party, or you leave trash in the common areas, or perhaps you engage in disruptive or abusive behavior at the pool. As soon as that party ends, or you pick up the trash, or you leave the pool, you have corrected the problem. And so since it's corrected, there is actually no next step, and no hearing and no potential fine. So it really is this odd loophole where we never really anticipated that as soon as you stopped the activity, it was corrected, and so you can't go to the next level. And unfortunately, there are situations, and I think this condo association was a perfect example, where you've got repeat bad actors, and there's no way for the HOA or the condo association in order to go ahead and remedy it, even though it happens again and again and again. So what this bill does is three things. First, on lines 24 through 27, it just makes clear that all associations have the authority to ensure compliance with the rules. Also removes prohibition on fines for non-payment of assessments less than 60 days, which can rack up. 35 through 37, that just reinforces existing due process and cleans up some language. But the meat of the bill is lines 43 through 45, and this is meant to address those repeat violations. And so basically what that line amendment reads is, if a member repeats a violation of the same provision of the rules within 12 months, within a 12-month period after they've been given notice and an opportunity to be heard, then the association may take action without providing a member further opportunity to be heard, right? So you've already gone through the process, and within a 12-month period, you've done that violation again, and so that's when they can go and say, all right, hey, we've given you a chance, and they can impose that $50 fee. I will tell you, and I really appreciate the administration approached me early in the process to express some concerns with the original version of this bill. We were able to go ahead and work with DPOR and that's where the language came from, to go ahead and address that concern. So again, that's the issue. That's the fact pattern we're trying to correct, and really just appreciate the subcommittee's consideration. I did have somebody from the Providence Square Condo Association who wanted to testify, wasn't able to get in, but I think he would just simply concur with what I've gone ahead and related.
Understood.
Thank you, Mr. Chairman.
Are there any questions from members of the committee at this time based off of that great explanation? All right. All those in favor of the bill, if you'd come forward, state your position.
Good afternoon, Mr. Chair. Pia Trigiani, representing Community Associations Institute. This is a bill that really lends itself to allowing associations to resolve issues at home rather than having to escalate into litigation. It's a way to encourage folks to compliance. It's not intended to be punitive, but to help them resolve the issues at home. So we supported the bill. Thank you.
Question for the witness. Ms. Trigiani, is there any restriction in the current code on this that would prevent someone of an additional right to be heard? I know that was language at the end of the bill that said that after notice has been given, there doesn't have to be further notice given to the association member or any right to be heard. Is that current law, or is that new language?
That is new language, Mr. Chairman, to address the recidivist, the return, the recurring violation of the same provision that's being violated. That was the change that Delegate Bulova spoke of to address, to make sure that it's clear that an association could not abuse it and and avoid a hearing for a different kind of violation. It was the language of the amendments, the line amendments, is to make clear that it has to be the same violation of the same provision of the Declaration or the rules and regulations.
Understood. Thank you.
Thank you.
Is there anyone to speak in opposition to the bill? We do have one person to speak virtually. Ms. Johnson, if you could call our first witness and only witness.
Yes, Mr. Chair, we have in opposition of the bill, Vic Nichols.
Ms. Nichols, if you could unmute and go on video and explain your position.
Okay, thank you. Oh, my video is broken.
This is great intent and purpose. The problem is there is in this where it says for any violation of the declaration or rules and regulations for which the member or unit owner or his family members, tenants, guests, or other invitees are responsible. That is very, very broad. If you have an HOA covenant rule, which many do, of where you have to go to the HOA if anything happens, like obnoxious or something, that can be abused. And many HOAs won't even enforce that original rule. I have seen one where a complaint was made on a neighbor who likes to grill a lot in the summer about the fumes and smoke that come from it, and that was an issue. So those types of things with that particular language right there, I think is way too broad. Thank you.
Thank you, Ms. Nichols. It's back before the committee. I'll give Delegate Bulova a final word.
Mr. Chairman, and again, thank you for the opportunity to kind of lay out what the issue is. And so, we're just really trying to make sure that we're able to, in a fair way, with due process, ensure that we're able to deal with repeat violations and make sure that people are able to, sometimes people aren't good neighbors. And when you're living in those kind of close quarters, you just want to make sure that your condo association or HOA has the authority to impose those or enforce those rules. And hopefully everybody can get along. But I appreciate your consideration, Mr. Chairman.
Thank you. Delegate Coiner.
I have a question, Mr. Chair.
Go ahead.
So, and I've looked at this so many times, and now it just shows you keep looking at something, you find other things. So let's say I have a violation, and then it's grass cutting, right? Let's say I don't cut my grass, and I get a violation for it, and I get a hearing, and I didn't cut my grass. And then next month comes around, you've noticed me again, I don't cut my grass. But then I cut my grass for 9 months. And I'm a great neighbor. And then I fall off the wagon and I stop cutting my grass again the next year, right? So a year goes by, and the next year I started all over again. Is that all considered the same continuous repeat violation, or where in here is there I complied and then it restarts?
Yeah,
but I do cut my grass for the public record.
Not during the General Assembly session. She doesn't cut her grass.
I'm sure it looks meticulous, and that's where I think DPOR added some good language in there. We had to kind of pick a point at which you would kind of reset that clock, as you said. And so the new language in there has that within a 12-month period. And so if you're good, mess up, but we had to kind of pick a window, and that was the window that we best we could come up with.
Follow up, Mr. Chair.
Delegate Coiner.
But I'm only cut off from using amenities, we'll say, so long as I continue the violation. I remedy it, or if I go to court and I win, I get back to being able to I either comply because I agree I violated, or we go to court and it's resolved and I have access again, correct?
Yes, correct.
Any other questions? Seeing none. Committee operates by motion. It's been moved and seconded to report House Bill 2098. Ask the clerk to open the roll for a vote. That bill reports 8-0 with amendments. Thank you, Delegate Bulova. That's the end of our docket of House General Law Subcommittee 2. Committee shall rise. It'll be followed by Subcommittee number 1. That's Chairman Fowler.